Life, Loss and Legacy is a general information podcast only. This does not constitute professional advice as we simply don't know your individual circumstances. If you do have any questions, please be sure to contact the guests of the episode. It should also be noted that the opinions expressed by the guests and host of the podcast are theirs alone and do not represent the opinions or perspectives of their employer or any other associations. That's enough warnings. Let's get started. Hello and welcome back to Life, Loss and Legacy, a podcast from Planning Solo to help people navigating those first few years after the loss of their partner. My name's Jordan Varga. I'm an independent financial planner with Planning Solo, and I'm happy to say that I'm joined today by a very special guest. His name's David Patkin from DMP Legal. Thanks for joining us today, David.
Hey, thanks, Jordan. Great to be here.
Now, the reason I've asked David to join us to talk about today's topic is he has a great deal of experience working in the space that we also operate in. So David has over 15 years of experience advising clients on wealth succession and the administration of their estates. He's worked at a law firm, RB Flinders Lawyers in Melbourne. He's also practiced as an estate planning lawyer within the NAB and then ANZ private wealth banking teams. So he's worked with a wide variety of clients, dealing with a lot of complexity, some high net wealth clients, and dealing with that transition from what was in place to what now is needed. So I've asked him along to join us today to talk about the roles, the rights, the responsibilities, the risks of being an executor. So thank you, David.
Thank you, Jordan. Great to be here, yeah.
Now, we'll hop straight in because there's a lot to cover. This is such a big topic. And as I mentioned before we started recording, that the more I learn, the more I realize I don't know. So we might start at the really simple fundamentals, because for the people that we're talking to, they might be juggling a lot of new information and a lot of new processes they need to work through. So we'll start at the very basics. What is an executor and what do they do?
Well, I can even go one step before that, because as you said, a lot of people jump right into it. And once you've mentioned the role of the executor, you're assuming that that role needs to be fulfilled and a grant of probate is even needed. And I get this a lot. I get a lot of clients who come to me saying, got to get the grant. And I'll say, well, hang on a minute. Let's have a look at the assets, because the assets and how they're owned will inform exactly what you need. Because at the end of the day, the role of an executor is to stand in the shoes of the deceased person and not only stand in their shoes, but be recognized as the representative of that deceased person by the banks, by the land titles office, by all of these sort of institutions and organizations that control the ownership. They only want to deal with the person that is officially, identified as the deceased person, the representative. Now, that's not an issue where the asset automatically transfers to a survivor, so a jointly held asset. So, for example, if you've got a couple and they own all their assets jointly, the principal place, their bank accounts, they might not even need a grant of probate. And this is something that, sometimes, I've had clients who go to a law firm saying, they said we need a grant of probate, and I'm looking, and there's nowhere that they need it. So that would be the first question: is that even required? And this is where we, sorry, you were going to.
Oh, no, it's fascinating. So, just bursting with questions. I guess the first one I'll hop into is, so the deceased leaves a will. The will says, I nominate so-and-so as my executor. But you're suggesting that even with that in the will, if the asset base doesn't support that requirement, they do not need to become the executor.
Don't need it. I mean, when you go to the bank and you wave a grant of probate at them, they'll look at you and they might even smile and they'll say, it's a jointly held account. We recognize
it's yours by rights anyway.
It's all yours. It's all yours, yeah. And this goes back, I think, to the estate planning. And this is why the estate planning is really important, because I've had some people who, a couple and one of the, one of the couple is undergoing, I don't know, cancer treatment or something. And if they've been given a finite time, couple of years or something, and if, sometimes they'll say, get all your things in order, get all your finances in order, get ready. One of those things can be, if you've got some accounts or assets held in your sole name, make it a joint account or wind up that account, and that'll leave the survivor with a lot less to have to deal with because there's nothing worse than having to get a whole grant of probate just for one account, um, or
Oh,
some asset where you don't have to. It's not only the expense; it's also you got to go through the whole process when you're grieving and all of that, and
mm,
assets are frozen, you can't get them, and that can also make it worse when you're trying to grieve. So part of the getting things in order can be to tidy up those finances, those accounts. I mean, sometimes you don't want to do it because, for example, if you're going to move a share portfolio over move a property, there might be, stamp duty and capital gains tax. So there might be a scenario where, no, that's cost prohibitive. And
mm.
because the transfer of those assets via the will won't trigger, any of those taxes. So it's not to say that you can do it for everything, but I think the whole idea of the estate plan is to really be aware of that. So that if there is something you can do to save, some legal fees, and then my legal fees I want to be charging, but I'm happy to yeah, point people. And also obviously that's from a to make the process easy, but then also if you're trying to protect your estate from
Mm.
claims, you can do a lot in the estate plan to not prevent a claim, but what we're trying to do there is reduce the size of the estate. So, hey, people can make a claim and they can knock themselves out, but there's not much there to really fight over. So,
Yeah.
that's another strategy. So but I mean, there's a lot we can talk about the applying
Well,
for probate and all that. But yeah,
I think the point you make there around the administration that follows losing somebody, there's that disconnect between the personal grief, the emotional impact of that, and then this really dry, cold administrative process that's required that can go for 12, 18 months, even longer. So if the will maker can maybe help to ease that process a little bit beforehand, within reason and within good sense, fantastic. Coming out of that, maybe they can make that process a bit smoother. It's one thing that's really opened my eyes. I mean, each of our roles, admin's a big part of it in every part of what we do. So it becomes normal for us. But if you're somebody who's been running the household and not involved in all the day-to-day financial pieces, and now all of a sudden you've got this ream of paperwork you have to do, it's I don't know, it's just such a jarring dissonance, I think, between what you want to do and where you are. But
yep,
let's say the will stands, the executor is required.
yep,
You mentioned earlier they stand in the shoes of the deceased. So what does that
yep.
look like?
So again, I had just last Friday, I had a husband ring me up. His wife had died, and obviously people think they notify people, and then they think, oh right, I've got to speak to the lawyer to, what do we do about the estate? What do we do about the estate? Nothing moves until you get the death certificate, and the death certificate is usually at least 2 weeks away from the date of death.
Mm,
So I tell clients, survivors all the time, look, don't worry about it. You just focus on grieving and that process. We can't do anything at the moment anyway without death certificate. Nothing moves without death certificate. So you just focus on that. So one important element, you mentioned the will. Of course, that is an important element. But people are only going to, this process only starts with a death certificate. Otherwise, if that wasn't a requirement, people would be claiming people are dead and trying to deal with their assets. So death certificate is critical. And sometimes it can be delayed a lot longer than 2 weeks if there's a coroner's investigation, into the
I'm glad
cause
you're
of
touching
death.
on that because I think that's something that
Yes.
people are surprised by is that not every death involves a coroner's
Mm.
investigation, but when they do, it impacts the process, doesn't it?
Yeah, because depending on the asset, I mean, I'm not sure. I think to a certain extent, life insurance can depend on this. What was the cause of death? Was it, suicide or what it was? So often, if you present, there's two types of death certificates you get from birth, deaths, and marriages, and one just has sort of like a confirmation that they've died. The other one has the cause of death on it,
Mm,
and a lot of places will require the death certificate, the probate office included. They require a death certificate with the cause of death on it. Um, Sometimes, if there's a huge delay from the coroner, if you explain that to the court, they will accept that and sometimes grant the probate. But yeah, so death certificate, we need that. And then if we've got a will, then of course we need the will. But if someone hasn't got a will, it's not to say that things suddenly grind to a halt and there's anarchy, or there's, things go crazy. Um, Basically, everyone, even people who don't have a will, they actually do have a will, but that's contained in the legislation of the Probate and Administration Act. So that sets out who gets your estate. So that sets out your will if you don't have a will.
And they're different in each state, aren't they? In each jurisdiction, those rules are slightly different.
Slightly different, yeah. And also overseas countries, we don't have to get into a lot of that now, but depending on the asset, whether it's a real property or it's cash, it gets treated differently if it's overseas. So that's a bit of a rabbit hole. But yeah, the big difference, and you might hear these words, if people are talking about a grant of probate, okay, they're using that word probate, that means we have a will, okay? If you hear people talking about administration and letters of administration, sometimes you'll hear that. That means we don't have a will. Also, it can mean that we don't have the executor named in the will. So the executor named in the will has died, or yeah. So then we can be talking about letters of administration. Look, at the end of the day, it's the same thing. It's basically a piece of paper stamped by Supreme Court of Victoria or the Supreme Court of the state that you're in. And then that's what the banks need to see to basically recognize that person as the representative of the deceased person. So that's the grant of probate. That's the letters of administration. That's a document that we need to have, to deal with the assets.
And we have another episode coming up where we talk about intestacy, where you've passed away without a will and you're falling into the legal or the statutory requirements. As an executor, though, is it fair to say, I mean, this might be too general, is life, no, that's a bit too glib, is the process easier if you're an executor?
It makes no difference if you're an executor or an administrator.
Okay.
Once you're recognized, you're recognized. When I say easier, you're dealing with these bodies who control the asset, and banks are a classic example of this, where you front up, you've got your little piece of paper, your grant of probate, you go up to the bank and you say, hey, now you'll recognize me, let's go. You've got to remember that you're dealing with the person who is at that branch, and you'll go into one branch and get one person who may have no experience with dealing with grants of probate and deceased estates, and they'll get all flustered and they're not sure what to do. You go into another branch with someone who has a lot of experience, and the whole process can be so much different. So this can be very frustrating, I think, for executors and administrators, where depending on the person you get on the day, it can be quite smooth and helpful, or it can be very unhelpful. And again, a lot of the times the executor is grieving over the loss of their loved one, and to get this frustration at the bank, very, very, very difficult.
That's a really good piece of feedback, because I think we're talking about the process in theory in this episode, really, aren't we? Like, ideally, here's the flow and here's how it works. But the on-the-ground reality, when you're dealing with people with different experiences, different knowledge, you hear about the frustration of calling Superfunds or Centrelink or something like that. It's so variable. So the feedback we always give to people going through this is keep notes, dates, who you spoke with, where you were, and just try to keep track of it that way. But beyond that, just accept that it's going to be a roller coaster. It's not going to go smoothly, I guess.
Yeah, and of course, the more assets you have in the estate, the more of these sort of discussions and frustrations, you're going to get. And look, it's not to say that it's always frustrating and bad. Some different banks, different share registries, it's a part of life. Okay, so they have deceased estate teams.
Yeah.
But like any, in any bank or any organization, there's always frustration. You send documents in, they can't find them in the system. You've been on hold for half an hour or for 45 minutes or longer. I'm sorry, we can't find those documents. Did you send them in? Where did you send them? And then suddenly 10 minutes later, oh, here they are. Oh, yeah, I've got that. And again, that's bad enough when you're just dealing with day-to-day problems with the bank that you're having. But on top of that, if you're grieving, or you've got some problems with the estate, some beneficiaries who aren't happy, and some other pressures, The classic pressure is beneficiaries wanting their money. As soon as they hear that someone's passed away, they start making plans. Whether
Mm-hmm.
they start going to auctions and making plans based on the money that's going to come in, and that can be frustrating when I've had beneficiaries who have signed contracts, and they've got days of settlement, and assets. This process has to go through, and
Mm.
you've also got in Victoria a 6 month rule where you shouldn't distribute the assets, because there's a rule where if someone makes a claim and you've distributed the assets, then you as the executor are personally liable for those assets. So there's a few things to navigate there, and again, those issues won't arise if it's quite a simple estate and everything's going to one person and there's no other beneficiaries in the wings.
Mm.
But where you've got either multiple beneficiaries or you've got more complicated assets, things can get complex pretty quickly. And yeah, when you've got a lot of money at stake and you've got beneficiaries who are basically demanding where's my money and why are you holding my money? What are you doing with
Mm.
it? That can get pretty stressful.
The
Yeah,
whole
yeah, yeah.
interpersonal dynamics of the estate is a whole nother realm. Like it makes everything so much more difficult than sometimes it needs to be. But with executors, I'm curious, when does their responsibility begin? I mean, bluntly, is it when the person's passed?
Not exactly. It's actually, and this leads to, do you have to be an executor? If
Mm.
if if you've been appointed by the will, do you have to do it? Are you forced to do it? The
Yeah.
answer is no, unless, and this is a court word, you have intermeddled with the estate.
It's a great word.
Intermeddling. If you start the process, so this is a bit of a bit of a funny one, but if you start the process and you take steps to be the executor and you hold yourself out, or you deal with some asset holders, and you start the process, but you haven't actually been given the grant, and then if you turn around and say, no, this is too hard, I want out, it's not as easy as dropping out when you've taken some steps. So the best thing that an executor can do if they don't want to be executor is to do nothing from the outset and
Hmm.
say, I don't want to do it. Now, the obviously the next question is, okay, well, if that executor pulls out, what happens? Um,
Mm.
if the will allows for an alternate executor, then it'll then default to the alternate executor. Okay. Or if you've been appointed as an executor together with another person, then it will be that other person who can do it. Because that's the other thing is, if you've been named as an executor, and or as a will maker, you've named two people, it doesn't mean that both people have to do it. Yeah, absolutely. If you don't want to do it, you don't have to do it. I suppose the question is, well, why wouldn't you want to do it? Um, People sometimes get concerned. Oh, I don't know what I'd have to do or how to go about it. Most people will engage a lawyer to assist them, with the application.
Is that,
And
sorry, David, is that normally the lawyer that drafted the will, generally?
no,
Is that allowed?
it can be.
Yep.
Beware of clauses that lawyers drafting wills put in their wills, saying that they have to use that law firm in the administration of my estate. Most of the wording, if you look at those clauses closely, most of the time they'll be, it is my wish that, it'll
Mm.
be in those sort of terms, because the executor can take their business wherever they want to go.
Yeah, okay.
Absolutely, they can go back to the lawyer who's holding the will. Often the lawyer will be holding the will, and they can engage that law firm, but they can engage anyone they want, or they can actually, it's set up to do it yourself.
Mm.
It's the probate office, especially. I can speak mostly, obviously, for the probate office in Victoria. They have a great phone line where you can ring up, and they won't give you legal advice, but they'll definitely assist you with the application for the grant of probate, because it's set up for lay people to do if they want.
Which is good. That's great.
That's great, right? The only
Yeah.
difficulty with that is that when you make the probate application is actually an affidavit, which is
Oh.
essentially a sworn statement. Okay, because you're presenting this evidence to the court, and the evidence being that this person has died, that this is their will, that you should be granted, the right to deal with their estate. So that is actually an application to the court. You are actually giving evidence to the court. And whenever you give evidence to the court, it has to be delivered either by way of, standing in the dock saying, I swear, this is the whole truth, the absolute truth and all that. Or you can give written evidence, which is by way of a sworn statement and affidavit for a court. Statutory declaration is another form of sworn statement, but the court requires it to be done via affidavit.
Mm-hmm.
And the requirements of an affidavit are that they have to be witnessed by a lawyer or a judge or someone. It's a very short list of people that can witness affidavits. So if you're making your application yourself, you've either got to go to a lawyer to sign it in front of, or a police station. And if you don't have everything perfect, the probate office will requisition you, ask you questions. No, this isn't correct. They'll knock it back and they'll say, you need to fix this up. And that can be a frustrating process if you don't know what you're doing. So it is a DIY process, but I get a lot of, well, not a lot, but I do get executors coming to me saying, look, I'm over this. This has been knocked back by the Supreme Court, 2 or 3 times. And they feel that it's the court sort of dismissing them and not being very nice to them. But there's certain things the court can assist, but they can't assist too much if you know what I mean. They can't give legal advice. They can't really, be your lawyer. So the executor, most of the time they'll get a lawyer to help them. So being an executor, because I know that part of your query was, well, what are their, when is the process start?
What do they actually have to do? Yeah, what are they?
Yeah. So they're like, technically they are representing the estate, which means that if someone makes a claim, they actually make the claim against the executor. They sue the executor, and that can.
So this is a really interesting point, and this is one of our bigger topics will be the risks involved. Now, in superannuation, you leave your benefit to the LPR, the legal personal representative. Is that another word for executor or
yes,
administrator?
Absolutely.
Yep.
Same thing. Yep.
So not only are you standing in their shoes, for legal purposes, you're on the hook, so to speak.
You're on the hook. You get sued, and again, it's not you personally; it's you as the representative of the estate. So if you get sued, your house and your assets aren't on the table. Okay. It's only the assets of the estate that are on the table. And but again, if you get sued, your lawyer's going to give you advice about whether to fight that claim, settle that claim, what you should do about the claim. And not only that, but any claim that you settle has to have the agreement of the other beneficiaries. So if you're the executor, the beneficiaries are fighting, one beneficiary sues saying, I should get more than that. If you're trying to settle the claim, it requires the other beneficiary to agree. If the other beneficiary doesn't agree, on we go to the big court case. Okay, There's nothing you can really do about it because it's the beneficiaries that have to agree. So again, you're definitely you'll definitely be in the crossfire, but you'll be shielded definitely personally because you're only in the crossfire to the extent that you represent the estate, and you'll have your lawyer there advising you about what to do and what not to do. So yeah, I mean, I can't hide the fact that you are ultimately responsible, but again, it's not you personally, and that's sometimes that concept is hard for people to grasp.
Definitely something I'd love to unpack because I think there's some taxation elements as well that they come into play as well. So when we talk about the risks and the obligations a little bit, but I'm curious with the executor's role itself, what are some of the really big tasks they have to make sure they're ticking off as they work through that process?
So they've got to find all the assets. Okay. So sometimes that'll be easy because the deceased had great records, and sometimes that'll be a nightmare because they don't keep any records.
Or they're all kept in a shoebox.
Yeah, or they delete all their emails. So, and again, I've got a client at the moment who, I can actually do a lot of the work, or your lawyer can do a lot of the work by engaging with the banks. But if you have no records, then I've got to contact every single bank and say, do you have any accounts? in Barker's name. You
Mm,
know, and just do a massive search, which can take a long time, and will be very expensive, obviously,
mm,
when you ring up all these organizations. And same with shares, sometimes if you haven't got the SRN or the HIN number, um, or you haven't got a broker to contact who's managing all the shares, if the deceased was doing it all themselves,
mm,
that can be quite a lengthy and tiresome process. So that's a responsibility of the executor to get all the assets in. It's not to say that if you miss an asset, it's gone, you can never get it. But again, if you're dealing with beneficiaries, and you're missing assets, left, right, and center, they're not going to be very happy. They could, executors can be removed.
mm.
It does require a court application, and the executor has to be doing a pretty terrible job to be removed. The oversight of one or two assets is not so bad, but mismanagement, which could be failing to deal with assets over many years. And I've got this at the moment. I've got a property that's still in the late father's name, who died 10 years ago. So you know that can happen. Assets can slip through, or people can just not deal with it, because there's no probate police or people who come knocking on your door saying, "Hey, why haven't you done this?" A lot of
Yeah.
it is if the a lot of the people who will scrutinise what you're doing are beneficiaries, and for this property that was still in the late husband's name, the sole beneficiary was a wife. So she just kept living in it, didn't do anything about it, and so it just remains in that deceased person's name.
That
Yeah,
inertia kicks in, and you just keep going along. And so
yeah,
I'm an executor. I've assumed the role, so I need to check the records at home. For instance, if it's my wife, check the records at home to see what bank records there are. If there's any skerrick of information about a bank account that was once held, then I send off a notification to the bank with the death certificate, presumably, and the probate,
yep. And
in
then as
theory.
soon as you do that, this is the other fear. As soon as you do that, that account gets frozen.
Mm, mm,
And again, this goes back to those jointly held bank accounts, because if that was a joint bank account, wouldn't get frozen. Nothing would
mm,
happen. Now, obviously, if you've got direct debits coming out of that account, they all stop. Okay. It doesn't affect money going into the account. Okay. Once an account's frozen, it will be able to accept deposits, but any direct debits will stop. So it's not a people are very, very forgiving, or organizations are very, very forgiving when they're just dealing with a deceased estate.
mm,
Even mortgages and those sort of things, there'll be no penalties. That'll all get waived. Everyone waives penalties and things like that. But of course, the bank will be keen to know what's going on.
mm.
And as long as they're able to get their repayments, which are usually done by direct debit or an offset account or something like that, as long as there's funds in there to continue to fund that. But even if there's not, or even if things get frozen, they'll be very understanding. They know it takes time for a grant of probate to come in. They know these processes. So again, you don't have to panic about all of that.
Mm.
But it's more about, yeah, as you said, um, finding those statements, and getting, for the purposes of the grant of probate, there is in Victoria, and it is different state to state, but in Victoria, part of your application for probate requires a inventory of assets and liabilities. So you've got to itemize every single bank account, every single shareholding, every property, not necessarily super unless it's paid into the estate. Super is usually outside of the estate.
Mhm.
But you've got to itemize all of these things, and they've got to be the correct value as at the date of death. So you need statements from the bank that say what the balance was at the date of death. That's a critical time at that. And we know that things change. And so those assets, the values might have increased or decreased over time. But it's critical. The probate office wants the value of the estate at that time. Yeah.
So not only is the probate process, once the form's in, potentially lengthy, that data collection piece could also be a very prolonged period. So probate could take a very long time, regardless of the stage you're at, just to get it through.
Yeah.
Um, okay, so bank accounts sorted. You mentioned mortgages. We notify the lender. how interested is a lender going to be with maybe the security of the house or the ongoing repayments? How do they normally handle that?
So they are not going to simply say, "Oh yeah, okay, we'll transfer that loan over to you, surviving spouse. That's all good." They can't do that. They've got responsible lending practices.
Mm.
And if the deceased was the breadwinner and earning the money, and the survivor hasn't got an income, then I'm sorry, but unless there are other assets in the estate to pay out that loan, such as the proceeds from super, life insurance, if there's not a big fat sum coming in to knock out that loan, or we can't refinance in the survivor's name,
Mm.
we've got to sell the property, and no one wants that. And again, this goes back to the estate plan, and it actually goes back to my time at ANZ and NAB, because in that environment, I wasn't a lawyer working with other lawyers. I was a lawyer working with financial planners, with insurance advisors, and so we were able to identify that possible weak spot in the estate, because we sort of basically role played. Okay, how do things look like for the survivor? You
Yeah.
know, are they going to be able to keep that investment property that provides that income and the principal place, of course? And is life going to be as comfortable as possible when they exit? And if they're mortgaged to the hilt, and they haven't got these, super or other assets that are going to be released on the death to knock out all those debts, we're going to have to sell some assets here. So
Yeah.
that plan is really important, because the last thing you want to see is the surviving spouse not only again having to deal with the grief, but having to sell the principal place, with all those memories and with all those cherished,
And
feelings
just be
about.
worried about how that period of time before you make the realization you have to sell it, there's still that period of uncertainty. Can I keep the house? Can I stay here? Where am I going to live? That all feeds into it as well. And like you're saying, the planning's one piece, funding it is the other part.
Hmm.
And I suspect some of the people listening, they may have inherited some really big estates, but there's a lot of debt in there and it becomes very complex to untangle and makes it very difficult. But so at some stage they may or they will, if that loan can't be extinguished, the sale of the house will be required in order to balance things. Um, Other assets, I'm just thinking of other assets. So shares are one that can pop up. Shares are always a bit of a headache for us when it comes to working through an estate. What's the process the executor should be following with a share portfolio?
So shares can either be what we say transferred in specie, which just basically means you don't sell the share, you just transfer the ownership of the share to the beneficiary. There's no trigger on CGT, or anything like that. It doesn't mean you get away scot free. CGT would transfer with that, but you can actually transfer the share itself, or if the beneficiaries aren't interested in the shares, you can liquidate them, and then the estate will pay those CGTs and any expenses around that, and then the liquid funds will be released into the estate. So you've got time. It's not as I said, often I'll get people who ring me a few days after the death, and even before they've done the funeral, sort of thing. What are we going to do about these shares? What are we going to do about these bank accounts? And again, I just say, don't worry. You've got Not only have you got to wait for the death certificate, but the application. So the death certificate takes a couple of weeks at least, 2 to 4 weeks for that. The actual application, if you had all of the assets, complete records, and you're able to get your application in very, very quickly, it's still going to take about another month for that. So already we're about 2 months out of the date of death, before we can even get the application, the grant. And then from that point, as I mentioned before, the 6 month rule, where you don't, the 6 month rule is not, you don't have to follow it. Okay, so the wording around this is, you can deal with the estate within those 6 months, but if you do, Mr. Executor, this is a sting in the tail. If you distribute assets before that 6 month period elapses, and there is a claim on the estate, and that claim is successful, and you've already dished out all the assets, then this is when it becomes personal. Okay, you would then be personally liable if you can't recover those assets. So if you've distributed $500,000 to a beneficiary. That beneficiary then goes to the pokies or whatever and blows the lot, and they don't have any money. There's a successful claim, and you turn around to that beneficiary and say, "Oh, look, I'm sorry. There's been a claim. I need some of that money back." And they say, "I'm sorry. I've blown it." Then you, Mr. Executor, Mrs. Executor, you are personally liable. So you have to dig into your own personal savings to meet that claim. So that's why we've got this 6 month rule, because what the court says to the executor is, if no claims have been made in that 6 month period, we want to give you certainty to deal with the estate without worrying
Yeah.
about any claims. Okay. So they say that you got this time period. If no one's made a claim within that period, then go ahead and distribute. Now, if you've distributed after 8 months and then there is a claim, that claim may still be able to be made, because the court might say, yeah, that's all right. You were overseas, you didn't know they died. Yes, we'll accept you bringing the claim. But because you're outside of that 6 months, the executor is no longer personally liable because they did everything correct. If you haven't distributed, and this is what sometimes we say to executors, we say, if you're worried about a claim and the 6 month has passed, get
Get
your
rid of it.
skates on, get rid
Yeah.
of it, because if you've gotten rid of it and then there is a claim, it's bad luck.
Mm.
Yeah. So it's really weird. Like, we'll say, no, relax. 6 months. Once the six
Do
months gone, go. Yeah. And I have had some estates where, on the stroke of midnight, they've started transferring funds. I mean, obviously that's where you've got concerns about claims. Where you haven't got the concerns about claims, and none of that really is a worry. But it just depends on the situation.
And
Yeah,
I can see the pressure for the executor in that moment. You mentioned earlier the beneficiaries are kind of clamoring for that money. They're going to auctions. They've made commitments when they shouldn't have. And the executor's going, well, no, it's 6 months. Will not be on the hook for this. There's a tension there. Families love a bit of conflict when it comes to estates. So that would be a very difficult role to play as the executor, I think. But I guess the lesson is stay strong, wait out the 6 months and make sure that you,
and communicate.
yeah,
If you communicate from the get go, you've read the will and you can see some pretty big distributions to beneficiaries. Let them know that there is a process that I have to follow. I've been advised by my lawyer, or get the lawyer to send it out directly to the beneficiaries. But even if you're doing it yourself, advise the beneficiaries that I have to go through this process. I can't distribute. I'm legally not allowed to distribute. Even though you technically are, but you can say,
yeah.
for 6 months. So please just be mindful that you're not really going to see anything for at least 6 months, up to a year.
Mm.
So just keep that in mind. Yeah.
When they're distributing, so they've found all the assets, they've all been listed. There's obviously going to be debts attached quite often, credit cards, personal loans, car loans, things like that. Loans to businesses, which businesses will be a different topic because it's such a big kind of headache. Is the executor responsible for making sure those loans are repaid before distributing?
Absolutely. They can only deal with the net value of the estate. So that also includes expenses that they personally have incurred. So if the executor's paid all the, because all the accounts are frozen, the executor's paid funeral costs, the flowers, the headstone, this can be 10, 20 grand worth of expenses.
Mm.
Sometimes they can, if they're really tight and the executive personally doesn't have the money to pay for that, they can take those receipts to the bank and say this is an estate, expense, and the bank will actually pay that for them.
Mm.
But if they've just gone ahead and paid for it, they are a debt to the estate. So pay yourself first, and definitely pay the credit cards, refinances. The bank just won't. Again, the bank just won't be happy to sit on that debt. The bank will want to either refinance it or have that debt cleared. So yeah, do that. And then the estate is only the net value of everything, which includes for super. If super's paid into the estate, sometimes there can be some pretty big taxes on super. We're talking hundred thousands of dollars, that would need to be cleared as well, because sometimes super funds, they'll pay you the whole lot, and it'll be the accountant that will discover, hang on, you've got $100,000 tax liability on this super. Sometimes they'll remove the tax before they pay, the balance. So you've got to be mindful of that, and that's where an accountant, again, there's there'll be tax liabilities potentially on the deceased personally. So they obviously might not have done their final tax return of the year that they died in,
Mm,
and for a lot of deceased, they haven't done the previous 5 years either. So
mm,
there might be actually returns money. I've had plenty of money coming back from the ATO into the deceased's name. Yeah.
yep.
And
Especially if the
then
old shares and there's franking credits that haven't been claimed. And
there's a lot of that. So it can be a worthwhile exercise. And then also for the estate, for every financial year that the estate is on foot and there are income earning assets, they'll have to do a return. And, they're just like another individual. If the income that the estate earns is below the thresholds, no tax will be payable. So, but again, rather than the executor, worrying about this, always engage an accountant,
yeah,
preferably one that's done a bit of estate work, and then just have them clear it up. And then again, you're, being an executor is enough of a obligation. You don't want to take on the obligations of tax and some legal, things. You want to keep it as simple and act on advice. And as
yeah.
long as you're acting on good advice, you're protected as well. Yeah, yeah.
And you mentioned earlier the executor can incur costs and claim that back against the estate. How are executors compensated for the work that goes through managing an estate?
Technically, they're not. It's a bit of a labour of love.
Hmm.
However, the court will recognise for a more complicated estate that they should be paid. Now, then the question is, what should they be paid? And there's two ways to go around this. Firstly, where I've got, again, this goes back to the estate plan, where I've got a complex estate and you're appointing someone, especially if you're appointing someone as an executor who is not a beneficiary, I'll always flag with a will maker, just to put you in the picture here, your executor here, who is not going to benefit from the estate, is going to have to deal with all of these assets, all of these institutions. And if they're a busy person at work anyway, you know, there's no benefit for them. So often I'll encourage the executor to put a gift in there for the will maker. Sorry, I'll encourage the will maker to put a gift for the executor. That can be a lump sum. You could put a percentage of the estate if you really want to, but most of the time it'll be a lump sum. There's probably indexed to inflation, that sort of thing. But if there is not that gift there, that doesn't mean the executor can't ask for money. There's two ways the executor can do it. They can get the consent of all the beneficiaries. So they'll say to all the beneficiaries, look, I've got to do all this work. I think it's appropriate that I get paid, and this is what I think I should get paid. All the beneficiaries sign off on that. That's done. Job done. That's good. If the beneficiaries don't agree to that, but the executor still thinks they're entitled, they actually have to make an application to the court, and then the court will assess that and then grant them usually a percentage, and it's usually a couple of percent. It's usually not that much, but it should be enough to cover their time. So yeah, again, absolutely their costs. So they engage a lawyer, an accountant. If they've even got expenses of taxis or things like that, they could claim that as part of it. But their hourly rate, their time, is not. They can't really put that in, they're not allowed to. It's really a labour of love by
Which
definition. Yeah.
makes sense. I mean, it's not a small job, which I think is something that's coming through really clearly. But you're right. It's a labour of love for the person that's gone.
Yeah.
A question I have about the estate: what happens when the debts exceed the assets?
Oh, bankrupt estate.
Yeah.
Yes. And this is if that's the case, then it's bad luck for those institutions that are not going to get full repayment of their loans. They sell the property, and yeah, it's not enough to cover the loan. They just got to take a hit. And
Mm.
one critical thing here for executors is if life insurance and superannuation gets paid into the estate, it's not always required to pay for a bankrupt estate. So wills really should have a clause in there setting out that any proceeds from super life insurance should be kept separate. so that we can let the estate go bankrupt and we can keep those proceeds for the beneficiaries. Okay, so that's if the executor mixes those super and life insurance with the estate to pay a bankrupt estate, then obviously those proceeds have gone. So again, the executor must be mindful that to keep those proceeds separate if they come into the estate. Often, you mentioned before that the super fund, the super death benefit nomination can be the LPR, and that's the executor. If you've nominated that, then they will flow into the estate. And again,
Mm-hmm.
going back to the estate plan, if we don't want that, if we want certain super or life insurance to go to a specific beneficiary or number of beneficiaries, then we can nominate them as long as they are allowed to be nominated. That being, you can only nominate a spouse, a child, or a someone who is financially dependent. So let's
Mm.
assume they fit within that. We can short circuit the process and just go directly to them.
Yeah.
So estate goes bankrupt, but all of these assets go straight to our beneficiaries and are not there to pay back the debts of a bankrupt estate.
Yeah, okay. That point about not mingling the assets, that's so critical. And I think it speaks to as well, make sure you have advice. Like as soon as your executorship is being triggered, bring in advice and make sure you don't make any of these mistakes. And we'll talk about some of the big mistakes that you see people make in a little bit, because I think it's good to know what to avoid as you're going through this process.
Yeah,
Um, One final question around the role of the executor before we move on to the risks again. What happens if the executor disagrees with the wishes of the will maker?
you can't do that.
Doesn't
You're
matter.
Because remember, you're standing in the shoes of the deceased person, and the whole idea of having a disagreement with the deceased person would imply that you're actually discussing these things with them and that sort of
Mm,
thing. Unfortunately, as much as you may hate it as an executor and you might think this is a ridiculous provision, you've got to follow that will to the letter. Even if you think it's not just, if it gives 100% to a charity and the deceased has left some poor child who's really struggling, the law will support that child in terms of a claim on the estate. But unfortunately, the executor has to follow the will. That's their blueprint.
mm.
There's no wiggle room. They've got to follow that will and distribute, yeah,
And that
in
can be
accordance.
complicated when you've got estranged children or maybe children who are spendthrifts and they could fritter the money away. You have to distribute it according to the will, whether you like it or not.
And that can be a strength because you'd be getting heaps of pressure and you just say, hey, there's the will.
Mm. Don't blame
What
me,
I
blame them.
can't, yeah, what can I do? If you think if the beneficiary suspect that there was an undue influence or the will maker didn't have capacity when they made the will, they might be able to get that unwound, especially if there's a diagnosis of dementia or something that predates the time they made the will.
Mm,
Then, oh, absolutely. Then we can revert either to a previous will, or if there was no previous will, then we go to intestacy, which may be what everyone wants. So we can
mm.
definitely look at unraveling that. But if they had capacity and that's what they wanted to do, and we can't find any undue influence or pressure that on the will maker that made them do it, um, that's the will. Yeah, yeah.
Yeah, yeah.
And going back to claims, there's a number of points you can claim at. So it's a strategy. We can target the will itself, or we can say, because as I said, there was concerns around undue influence or there was concerns around capacity to make that will. So we can actually attack the will.
Mm.
Or if there's none of that, we can say, oh yeah, all right, we accept that's the will, but we're making a claim on the distribution because yeah, and that's a totally different area of law. Each section is a totally different area of law, with different, history, case history, and all this sort of thing. And it's like, with any strategy, you look at the whole gamut and you look at, well, where's the weakest link that
Mm.
achieves the best outcome for me, and then you target that rather than, fighting an uphill battle against something that you're never going to win. You're better to put your resources into the area that you're going to have the best effect, the
I
best
think it
impact.
speaks to the power of the will as a document, which is why the original is required by the executor, which is why anybody who's had a will draft and had to sign off on it, it needs to be witnessed. It's all a very methodical and very detailed approach, and it can seem a little bit silly because it's a couple of pages of paper, but that will drive everything once you're gone.
And I think the main thing about that is that these couple of pieces of paper, are dealing with millions of dollars of
Mm,
assets,
mm,
you know.
yeah.
So that's where, again, you got to weigh up, if you've got a complex estate and you've got some problems with the beneficiaries, um, and you're doing a DIY, post office will, $25 that is going to actually, deal with millions of dollars of assets and complex sort of, yeah, that's where the sort of doesn't make sense, So you really want to
Don't
put
skimp on it. Don't skimp on that.
get it right, and then you'll a lot less problems for your executor and your estate. Yeah.
And speaking of problems, I mean, we've covered a lot of it already, but let's talk a little bit about the risks that can flare up for you as an executor. And financial and legal it will come to, but probably the big one that pops to my mind is that family conflict idea that people will get very annoyed and you will be the point person for that irritation. You mentioned earlier that communication is probably key there. What key points, I guess, along the way would you encourage communication from the executor?
Um, Again, everyone wants, and I'm assuming here that the executor is, a loved one of the deceased, and they're part of they're grieving as well. So you definitely want to have time to grieve, to grieve. But if you're engaging a lawyer, I definitely encourage the executor. I mean, the lawyer will do this in any event, but yeah, communicate with the beneficiaries around expectations, um, and doing all that work for you. You don't.
Mm,
Again, you can do it yourself, but you, it's not something you do a lot. I mean, you're probably going to be an executor once or at most, once, maybe twice, in your lifetime. And they're probably going to be so spaced out that you probably forget the first time that you did it.
mm,
So um, generally, and again, depending on complexity of the estate, just engage professionals to do it for you, and then you can, like you're still at the end of the day, you're still responsible ultimately.
mm.
So you still hold that position if you take it. Um, but if you use if you engage professionals to help you with advice, then if things get nasty with some of the beneficiaries, you can sort of basically hide behind the
You've got
lawyer
some
and say, well,
distance,
this,
yeah.
yeah. Whereas if you're doing it all yourself, then you'll get in heated, and it's nothing worse than you explaining things to the beneficiaries and you haven't been advised and you get it wrong, and then a
Mm,
beneficiary speaks to one of their friends and says, you know what, that's not right, or the beneficiary has a lawyer and the lawyer says, that's not right, then you can find yourself in some pretty difficult areas pretty quickly
yeah.
as an executor. Yeah,
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 rely on
yeah,
the
yeah,
expertise.
yeah, yeah.
Would would you encourage, and I really don't know the answer to this, but you've got an estate you're the executor of, and the will maker has excluded somebody who would have a reasonable expectation of being a beneficiary.
And again, yeah. Sorry,
Would
you
you
want to finish?
communicate with them as well, or would you cut them out of the communication at that stage?
And again, I look, as you can appreciate, people have been dying for a long time, right? So, so the law around this covers every single scenario, more than you can even dream up. The scenarios, you read, I mean, we read case law all the time, and the scenarios that pop up are incredible. And that's an exact thing. Some beneficiary asks the executor, I want to see the will. The executor thinks, well, you're not in the will. I don't have to show you, right? Now, that's a bit of a common sense thing that the executor's formed in their mind.
But just to size that, the executor is legally obligated to provide the will to all beneficiaries, or only upon request.
Definitely all beneficiaries named in the will,
Okay,
but
yep.
it doesn't end there. It doesn't end there. The will has to be disclosed to any beneficiary in the will, and any beneficiary, any person who would be a beneficiary if the person died without a will. So we go back to that intestacy
Ah,
scenario. Okay. So if the will cuts out a child, okay, but if that person died without a will, that child would be a beneficiary. That child has a right to see the will, even though they're not named in it. Okay. So, and this does happen because the executor will say, well, no, I don't have to show you because you're not in there. That's a big no. Okay.
mm,
And that beneficiary will go off and get a lawyer,
yep.
compel the executor not only to produce a copy of the will, but maybe even pay the legal costs. of that child's lawyer because they had to incur that cost to get something that they're legally entitled to. So again, why why give that response as the executor when you don't really know what you're saying? Every single scenario has case law, has legislation, has something guiding it. So there is an answer there. Yeah. So the short answer there is every beneficiary plus any person who would be a beneficiary via intestacy. And of course, you've got to know the intestacy laws to make that
Yeah.
call.
Across the different jurisdictions.
Yeah. Again,
Yeah.
depending on where the asset was, usually again, the law that applies is where the asset is. So if one of the properties, if you die in Victoria, but you've got a property in Queensland, it's a property of Queensland that governs that asset different to so things can get pretty complicated. And this is why last week I spent a whole day at a professional development conference with a bunch of estate planners discussing all of these scenarios and ins and outs. So we look at this all the time. We have to meet our obligations as being a professional. Yeah.
I think
So,
also that idea of not providing the will, I can understand it, and there's always a background to it. But I see these kind of things as every decision you make can either move you down the step towards conflict or away from that conflict. And maybe conflict's unavoidable, but if you can avoid it, I mean, by providing a document that really you had nothing to do with, you're just named in.
exactly.
Yeah,
And you've got
makes sense.
and that's what the executor has to do. You're not making decisions based on what you want to do. Okay,
Mm,
you're making decisions. You're clinging. You've got this structure. You've got this really good supportive structure of the will and the law. So that's your barrier. So that's where you can say to frustrated and angry beneficiaries, "Sorry, guys. It's not my decision.
mm. I'm really just the
I'm
vehicle for this."
I'm just doing what I got to do." But again,
Mm,
if that's not communicated properly, um, then so that's where obviously there's a certain expectation that you will communicate, just with
mm.
anything, with any professional, you want to communicate to your client, all that sort of stuff. But you don't necessarily have to knock yourself out to tell the beneficiaries everything. There's a school of thought that, well, they can go off and find out this stuff for themselves.
Mm.
But if you want to minimize the drama and take the heat out of it, just explain it to them. You're not giving them anything, any advantages or disadvantages. You're just explaining this is how it works.
Yeah.
And if they want to test that, if they go to their lawyer, their lawyer will tell them exactly the same thing. So problems can arise where you don't communicate that. They get certain expectations, or and then they flare up and there's a big argument, sometimes a fight. And then if they subsequently learn, well, that was right, they've still got this bad vibe.
Yeah.
And yeah, it's not a
Yeah.
happy
Things have
place.
been broken by that stage, and
Yeah.
try to preempt it with better communication and professional advice.
Yeah.
Which brings me through to that. I think the final thing I'd like to cover is what I'm keen to learn what good practice looks like as an executor, and I want to learn about that from the other direction, saying what are some of the really big mistakes that you've seen people make when it comes to managing an estate?
Generally, like any accounting, it's an accounting exercise. So keeping records, having all the information before you, dealing with things in a this probably comes straight out of the judgments, but dealing with matters in a timely manner.
Mm,
Big delays, where you can't explain why there's been a big delay. I've got a matter at the moment where the executor hasn't even made the application for the grant of probate, and because she's going through a family law, dispute
uh,
and all that sort of thing. So she's got other things on her plate, but we've got this estate and we've got beneficiaries jumping up and down. So um, yeah, just not doing things in a timely manner for no reasonable, excuse. And even though you can sympathise with her going through her family law problem, it's really no excuse. She should either renounce or step down as
mm,
executor,
yeah.
or just provide the information and get on with it. You
Mm,
know. So I'd say yeah, the big things are keep records of everything, and do things in a timely manner. No big delays that have no reason,
mm,
for that.
mm.
Yeah, 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 yeah.
I think that makes a lot of sense. And you describing this an accounting exercise just nails it, I think, because it's happening. You know, the train's rolling. You need to make sure you just keep track of it and keep accurate records and be able to defend and reflect on it as it goes through.
Yep.
And, you know, there's some areas we haven't touched on. We haven't touched on, you know, what can really arise in a dispute, funding disputes, things like that. But what I think we might do is we might draw things to a close. And if people did have other questions or wanted to run things by you, where's the best place to reach you?
Yeah, well, I mean, they can stop by the website. It's not too fancy, but it's got my contact details and email. You know, I'm happy on the phone. I mean, the benefit of being, you know, sole practitioner, and this is what I find a lot of clients appreciate, is that when they ring the number, they can just actually speak to me, which can be quite surprising to people.
Oh, yeah. And you return
Um,
phone calls? Like, this is not a normal
yeah,
legal practice. But,
yeah. Yeah, yeah. So yeah, so just jump on the phone. I mean, of course, you know, you can send through an email and things like that. But you know, often the query can be nipped in the bud pretty quickly with a couple of minutes on the phone. Um, so that's probably the quickest and easiest. And then it's always good to before that phone call to get as much information
yeah.
you know, as they can, because I might sort of ask a few sort of questions, and that's fine. I've got no problem with asking a few questions and saying, look, you need to find these things out first, and then we can have a better chat. Um, but yeah, just yeah, jump direct email or phone. Yeah, I mean it's fine. Yeah,
And that website is dmplegal.com.au.
yep,
And yeah, I think the diligence that's required to be a good executor, I think, can leave people a little bit unnerved or a little bit uncertain. So I think reach out to get good help, but also recognize that along the way you are going to have to make decisions. You can't just keep asking questions and asking questions. You are going to have to make some decisions at some stage, and you have the guidance and the capacity around you to do so.
and if you're got a big trip planned and the timing just is not good, you can step down. Don't
Mm,
you know most good wills should have an alternate executor appointed. So don't sweat it. Step down. It's not that bad. And that's why the will maker appointed a backup in the event that you couldn't do it or didn't want to do it. You don't have to submit a reason. You just say I don't want to do it, and bam, you're released. But don't remember that intermeddling. Don't
yeah,
intermeddle
don't need to meddle.
because
Keep it
and
clean.
and that's where don't start the process and then think, you know what? Nah, I don't want to do this. No, 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 no. If one thing you take out of this podcast as an executor is if you don't want to do it, do nothing, and
Mm.
then you're all good. Yeah, yeah, yeah.
We had Lucy Percy on an episode a little while ago around estate planning, and she said that she sees the will and the estate plan as that last act of love by the deceased. Being an executor is the last act of love you're doing for the deceased, but doing it fully and doing it properly and not sacrificing yourself is implicit in that. Don't martyr yourself doing something that can be quite difficult when you can, as David says, you can renounce it and get out of it.
Yeah.
Um, so I think the big ones are keep really good records, work methodically but don't rush it, be really detailed, seek really good advice, have a team of advisors around you. And those advisors should be people you're comfortable asking questions of, questions that
Mm.
might seem silly to you, they will have heard 100 times before, and just get through the process as smoothly as you can and just get to the other side so you can
And you
grieve
might not
properly.
need. Don't forget, you might not need the grant. I've told
Yeah.
I've told a lot of people, not a lot, but you know, I've told people over the years, you don't even need the grant. Don't even
Mm,
worry about it. Yeah, yeah,
mm.
yeah, 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 yeah. And yeah,
So
something to keep in
be
mind.
questioning, ask questions and work through it slowly. But we will draw it there. David, thank you so much for joining me. Thank you
Thank you,
for your
George. It's been
contribution on that.
great.
It's been really good. And thank you again for listening to Life, Loss and Legacy, the Planning Solo podcast for people going through bereavement. My name's Jordan Varker, and we will see you at the next one. Thanks a lot.
Cheers. Bye.